case to come before the court is Regina Hager versus Jason Hager. Each side will have 15 minutes in which to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. Just let me know before you start if you wish to reserve time and how much. Don't use the names of any children's if that becomes applicable. We have read your briefs and we're ready to begin when you are.
Thank you. Good morning. My name is Joseph Stafford and I represent the appellant Jason Hager. I will request 5 minutes rebuttal time. Okay. This matter is rather straightforward. It's a matter concerning a domestic violence petition. The transcript is relatively short. The issues are concise and set forth. The reason why this appeal is filed is under the circumstances of this. My client receives the petition the day before at about 2 o'clock, setting forth a hearing at 11 o'clock the very next day. So there's not a great deal of time. My client is not a sophisticated litigant. He's not a lawyer. He is a person that comes to court. And when the court makes the inquiry what they're going to do that particular day, the court says there's two options. The first option is go to hearing. The second option is you can agree. Well, actually, the law says there's a third option, and that's to grant a continuance. The court improperly misstated what the law is. Under Ohio Revised Code Section 3113-31D2A, Roman numeral 3, it actually indicates that the court can grant a continuance at the request of the respondent to obtain counsel. So the court clearly had a duty and obligation to inform the party that he had the right to counsel. There is no waiver of counsel that you typically see in most jurisdictions. When people proceed on a pro se basis, most courts follow the protocol of securing a waiver or a documentation saying they're not proceeding with counsel. In this particular case, that never occurred. And at various points in time, Mr. Hager says, this is confusing, I'm not following. He believes that he can have an order for both of them, and that's what he's requiring. At certain periods of time, the transcript is very difficult to follow because the magistrate is actually negotiating with the parties to set forth what was there. Opposing counsel is requesting things. Mr. Hager is there without counsel, and he indicates, I'm confused by this. Also, at some point in time, he requests an order upon his wife for the similar matters. He says, I want to make sure there's teeth to this, or the counsel said that, and my client indicated he wants it for both of them.
I was a bit confused as to the timing of the request for a continuance. Was it after they had resolved a number of issues, other issues in the matter, or was it right at the commencement?
It's at the start the court says what's going on. Then at some point you're confronted, you're a litigant, you're confronted, you can have trial or you can agree. Most litigants, if they're pro se, will go, oh, well, wait, I'm not here for trial. I will go the route of trying to get an agreement. And so he follows that route. At no point in time does the court indicate you're allowed to have counsel and you have the right to request a continuance, which is the court's obligation to do in reference to a litigant. These orders have severe ramifications. In this particular case, this has been weaponized in the divorce case, this civil protection order, and it's had tremendous detrimental impact upon my client. And so what the problem is, you can't engage in negotiations as a fact finder and then start recommending things, then threaten if you don't agree, you're going to trial. Specifically when he asks, if you follow what's on pages 25 to 26, he says, I need time. I need to hire a lawyer. I need to do things. And the court says, we've been here a half an hour already. You can either go forward. Counsel chimes in. Basically, they intimidate him into an agreement. And with a domestic violence petition, the ramifications of them are so severe and they have criminal connotations to it. If there's any sort of violation, you can be held in contempt civilly, but you can also be hit with felonies for a violation of a civil protection order. And this case has there's some ugliness in this case, but what's peculiar, if you read what actually happens, at some point in time, counsel says to Mr. Hager, we'll only do a 3-year order, right? That somehow there's going to be a consent to it, and Mr. Hager believes it's going to be mutual. He says, no, I don't want a 3-year order, I want a 5-year order. That alone should tell the court that there's total confusion here, and that's on page 36. If you read it, when I read the transcript, I was somewhat shocked by it, because I'm like, that doesn't make any sense, and the court should have stepped in at some point. It has a duty and obligation to pro se litigants. I'm sure this court is aware pro se litigation has just exploded in the last 5 to 10 years, especially in the field of family law and this area of domestic violence petitions and whatnot. So when you read it and it goes on, my client is totally confused with the circumstances of it. My client requests a lawyer, and the opportunity for a lawyer, the court says you should ask for it prior to the hearing. Well, that doesn't make any sense if he served it. There was no doubt in the record he served at 2 o'clock the day before. The hearing's at 11 o'clock. He asked for counsel, and at that point in time, the court should have said, you do have the right to counsel. I'll grant a continuance, limited as it would be, and there's no harm to the petitioner. No harm whatsoever. There's a temporary protection order that's issued. There's no harm granting the continuance. The court seemed to want to deal with this matter as quickly as possible, efficiently as possible, and they strong-armed the appellant. And that's the only way you can look at it, because in reference to this, we filed a motion for relief from judgment. We also quickly filed a motion for new trial. We briefed the issue in reference to this, why those were proper. We also sought 2 different remands to the trial court to rule on these things, because it was my belief that if the court sees what occurred, read the transcript, the trial judge would have vacated out this order. Unfortunately, despite your issuing 2 orders, sending it to the trial court, our inquiries, the trial court never made any rulings. So as we sit here today, my client's motion for relief from judgment, as well as motion for new trial, is still pending in the trial court. We filed our initial briefs early in this matter, I believe almost a year ago. So in our briefs, it might be a bit confusing. We say our motion for remand is still pending, but that was prior to a ruling. I think, Judge, you issued a ruling on the remand. The remand went back. We asked for a second remand, and the trial court basically ignored our request on the remand and ignored your orders. So under the circumstances, we are here requesting that, in fact, this court take the reins here, reverse the trial court's decision on this, because we have to set up the parameters for everyone to follow on these matters when they come to court. And what I mean by that is, if you're going to have pro se litigants and they're going to represent themselves, we need guidelines from this court to tell the trial courts how to conduct themselves. You can't say there's only 2 options when people come in unrepresented by counsel. And that 2 options is you can agree or you can have your trial. Either way is disastrous for a pro se litigant if they're not familiar with 31-1331, the revised code. I know many lawyers and many judges that are often confused by the particulars of that revised code section. It's long, it's confusing, and a pro se litigant at no point in time is going to know what that statute says when they show up for court less than 24 hours after they're served. So if you could mandate to the trial court that if in fact people show up and they're pro se, you have to give them the 3 options. You can go to hearing, you can agree, or you can have time to seek counsel, as my client requested. And unfortunately, the trial court gave him bad advice or a bad instruction, or basically stated something that the law is not. And that is, he did have the right to request a continuance, and the court should have granted the continuance. So I humbly request the assignments of error be affirmed and the matter be reversed by the trial court. Thank you.
What's the impact of his signing the agreement in your mind? Or, excuse me, the order where it indicates that he agreed to waive notice and hearing rights, and I've read the consent agreements and agreed to its terms.
Well, if you read the transcript, the court's filling out the form at the bench. Counsel's asking for him to check the boxes. So he's going through it, he's checking off the boxes, and basically he's handing the form to sign.
Your client was checking off.
No, the court was checking off the boxes. If you read it, the trial court's actually the one filling out the form. Counsel hadn't filled out the form. The court's sitting at the bench, I think just down the hallway, very small courtroom, filling out the boxes, filling out the form, and he's handed the form. 99% of the time, a pro se litigant will sign that form, almost always. Imagine yourself not being conversant in the law, not being conversed in any of these issues. You're confronted with someone wearing a robe, saying this is what we're gonna do. You either go to trial,
Although he was pretty assertive as to his demand for continuance.
and he lost that. Because the court says you only have two options. The court didn't tell him what the revised code actually says. The court is mandated to grant a continuance under those circumstances.
And I don't want to take up too much of your
Oh,
time
it's okay.
answering those questions, but thank you.
Thank you, appreciate it.
Good morning, I am David Lenahan on behalf of the appellant. Essentially, the appellant is claiming that he was under some sort of duress and that the court acted arbitrary, capricious, unreasonable, and unconscionable. All those fail as a matter of fact and law. When the matter began that day, first of all, he showed up, he voluntarily came there, Mr. Hager did, and
Did
the
he
court...
have much of a choice?
No, he doesn't. He does not. He has a choice. He doesn't need to show up for this proceeding at all. He has complete discretion whether to show up. It's not like a criminal case. The burden of proof is by the person that's alleging the domestic violence, and that can happen either with or without the other person being there.
But their allegations can be challenged, correct?
Absolutely.
And if he wanted to challenge that, he has to show up.
Yes, and interestingly, he didn't challenge anything. He hasn't alleged prejudice by going forward. He never said, I didn't beat her. He never said, wait a second, I have a defense to beating her. Never in his briefs and his reply briefs did they raise some sort of meritorious claim of prejudice. All they claim is for prejudice is that they didn't get to have the case heard on its merits. If someone says that all the time, then just imagine the Pandora's box that we would
Well,
open.
I'm not sure that's not what I glean as the prejudice. I mean, he didn't get to have an attorney. There's a difference. He could have had the case heard on his merits. Presumably, it would have been heard differently on the merits with an attorney representing him.
Perhaps it could have, but what occurred was the court said we can begin, and at no time does he say, wait a second, I need an attorney. Wait a second, and he waffles back and forth. The one time he says, my attorney couldn't show up, and then the second time he says, I don't have an attorney, couldn't get an attorney. But he agreed to voluntarily discuss a consent order. And he went forward with that. And we spent, to answer your question, a considerable amount of time, over a half an hour, made agreements on various things related to the house and the workplace. They both work at the workplace. Until it came time to argue about the car. The car that's titled to his name, and he was told that's going to be dealt with over in divorce court from a temporary order standpoint moving forward, from a protection standpoint from domestic violence. Would you agree to let her have the car? You can deal with it over divorce court. He says, yeah, I agree. She can have it. That's the argument that led forward to him wanting a lawyer. His car that she had been driving forever, and the dollar amount related to that. And then continued on with the remainder of all of the other things that were discussed throughout the rest of that morning to get finally to the ultimate consent decree. That's it. So the duress, as defined by Black's law dictionary, is some sort of threat of a wrongful act under circumstances that would make removing your free will to enter into something never happened here. He had the free will to negotiate each and every term, which he did. And it was lengthy, and including the 5-year instead of 3-year, he agreed to that. He agreed to the car and the house, although unfortunately we don't have in the record all of his other bad acts that happened after that, including some of the blatant.
If it's not in the record, we probably don't need to hear about it.
Absolutely. So you get to the point of what is the wrongful act in order to be under some sort of duress? What was the arbitrary portion of the court? And the court had said, look, we're halfway through this. We're a half an hour in this. We're moving forward. You could have asked for a lawyer at the beginning. We've started this. It would be unfair, essentially, to the other parties now to just have a change of heart over one term that you're arguing about the car.
So you're stating that at the beginning of this hearing, he never said he wanted an attorney?
No, in
The
fact,
transcript's not going to show any indication of him saying, I don't want to go forward today unless I have counsel, and the trial court said, that's not one of
absolutely,
your
Your Honor.
choices.
It's not until a half an hour in, somewhere around page 25, after we had discussed the whole issues of the house and the car and several items, that he then, when we finally get to the issue of the automobile, he then says, I'd like to have an attorney.
Is that the point at which the magistrate said that you only have two choices, and that's either to go forward or we go to trial?
Actually, I think the magistrate said it twice. He started at the beginning of the proceedings saying, look, we have two options here. We can have a consent decree or we can go to trial.
What about his contention that he also had the option of asking for continuance at that time?
He could have.
And that could do that, was the trial court obligated to instruct him that he also had that option at that time? Or-
No, because I think then the trial court could then say, well, you also have the option of not being here. You don't need to be here, you can leave. You have a lot of different options that you have here. At what point do we draw the line? Here, the options are, we're gonna get two things. We're either gonna have an agreement or we're gonna have a hearing. And he could have easily said, I'm leaving, I'm not gonna wanna have any involvement in a consent discussion. I don't wanna participate in that, I need a lawyer. He could have raised all at that point. He didn't. He didn't. Whether that's invited error, whether that's his sophistication, and by all means, the record is clear that this is a very sophisticated gentleman. He is no stranger to the court system, and that's clear from the record as well. So the court said, yeah, and that's right. At the end of the day, there are two things when you come forward. That court is what you're gonna have. Either consent decree, or we're gonna have a hearing. All the other things are just lots of other options that you could throw in there. At what point do you stop with all the options?
Would you agree that a domestic violence and protection order hearing, trial, is not the same as other speed at which they occur, that they get put on the schedule, all those things sort of aren't the same as any other criminal or civil type trial?
No, they're actually put on quicker.
They're
And
done
there's
within 10
reasons-
days,
and there's
right? That
reasons
hearing has
for
to be
that.
set within 10 days, is that
Yeah.
correct?
Yes, we put on much quicker with that, respect to that. And the record shows how he didn't receive the paperwork the day before. He was served the day before. He was well aware of it many, many days before that. And the record is indicating that, where he called a police officer at Strongsville and he said, well, because you're not served, you can still go get your car and you can violate the order because you're not served yet.
And all that's in the record.
That's in the record as well. And the reason why there was a problem with the service is because this matter was being held in Medina County, although he had temporarily resided in Cuyahoga County, although the day afterwards he moved back into the house and moved back into Cuyahoga County, but we had to get him served with the different sheriff departments. However, the court does that kind of thing, did that. But nonetheless, he goes to the court on that day and he voluntarily starts discussing all the different things, and it got resolved. And for some reason, he's just not happy now. And the question becomes, was this arbitrary for the court to deny a litigant the right to assert, I want to stop and get a lawyer? And if the courts have absolutely no discretion, that must become something that's etched in stone, that at any point a litigant could do that, then they could frustrate the entire process at any time. And that's what he attempted to do for a callous issue of the car. And when we got past that, moved on to all the other issues that then were finally resolved.
I think opposing counsel's arguing, though, that it's not just the car, it's the long-term ramifications of having the civil protection order on your record.
From what standpoint? I mean, the fact that he beat his wife.
Well, that's not even in the record. So my
By
point
his
is-
consent to this, you would have to assume that it is part of
I
the
didn't read that.
No,
I
because-
didn't read that in the
Sorry.
consent agreement.
There are consent agreements drawn up that don't have the violence portion in there purposely.
Right,
At least they're negotiated that way when there's an attorney involved. On
Yes.
both sides.
yes.
But any further infractions of for the next 5 years could result in, according to Mr. Stafford, it could be a felony.
You'd have to do several violations of it before it escalated into a felony, but yes, there is an enhanceable portion of the criminal side of this. This was a civil protection order, and whether or not it would become a criminal issue is only if he violated it and disobeyed a judge's order, and which this is a consent order. And that was very well put to him throughout the proceedings, where it says, look, this will have the same teeth as a consent order that would as if it was a judge's order. You know, we're moving forward with something that he knew was going to have that, and like I said, he's no stranger to law. He's been in prison before, so he understands what the ramifications of those things are, clearly from the record on that. So getting back to the issue of what is a judge to do, and was the judge acting arbitrary? Clearly, when a judge is halfway through this, and he makes a reference and he then wants an attorney for that, the question becomes, you know, what do you do? And what's the issue? And I think from the record here, it's very clear and straightforward. It was over a car, and then that, oh, okay, fine, you can have it, because we're gonna deal with that issue over in divorce court. And the rest of the items got taken care of. I don't think it was unconscionable. There's nothing unconscionable about this order, from the standpoint that these happen all the time, whether they're 3 years, 5 years, 1 year, 2 years. That's what the law is for. I don't think there was anything wrongful that was presented by the court as it relates to whatever threat he thinks he was threatened with in order to be coerced in removing his free will. The argument that they're putting forward is duress and arbitrary and capriciousness. Those are the standards that we got to look at. And the duress issue is, what duress did he have after being halfway through the proceedings, then make a claim that he wanted a lawyer, and the court say, no, we've come so far, we're going to, if you don't have to do it, you don't have to consent. We can stop right now. We'll be very clear. If you're not comfortable with this, entering into an agreement, it's okay. You know, it's fine. You don't have to. But we'll just move forward with the rest of the proceeding. You don't have to do a consent. The court is very clear with that. That's fine. He didn't have to. So what free will was taken away from him by saying, okay, I'm going to still proceed to try to consent and get an agreement on everything? And he got an agreement on everything. There's nothing that he's disagreeing with that says, oops, I wouldn't have done that. Oops, I wouldn't have said that Fridays instead of Mondays at work is how we were going to negotiate working at the same place. Or the first one to arrive at the house has to leave if the second person comes there because the long driveway that's nearly an acre long. All those different things. Do you need the code to the garage? What days how do you handle the emailing and all these other things that were, all those items were resolved. They were resolved. And he was okay with it. It's just for some reason now he says, I don't want that. And I'm going to use the issue of not having a lawyer to help me negotiate the car that's going to get resolved in divorce court in 2 months anyway. Because divorce court will be handled in that time period. So there is an inconvenience to litigants, which is a balancing factor at issue here. And there would have been an inconvenience to the appellee who had already started the process. Clearly, part of that balancing test that the Supreme Court requires is who created and contributed to the circumstances that gave rise to it. He did, because he didn't ask for his attorney early on. He could have said, look, I don't want to do a consent. I don't want the proceedings. Can I have an attorney? And perhaps maybe something different could have occurred at that point, but it didn't. He continued on and agreed to engage in those proceedings voluntarily. No one threatened him with going to jail. No one threatened him with anything that would be a wrongful act. Simply not. So the question becomes, at the end of the day, was the judge's decision arbitrary at that point in time when asked at that instant, after going through it for a half an hour, that he wants it? And then really, if you look at some of the remainder of it, all those things that get resolved. He's back on track with consenting to and agreeing to all of the different parameters that ultimately got in there, with checking the boxes and all that stuff. And then you're right. He reads this and he says, I voluntarily execute this and sign this, and he signs his name to it. You know, words matter. He signs the agreement. You know, even after negotiating it on his own, he then signs it on his own. No one held any duress to him on that. He could have said, you know, I've gone through this, I changed my mind, and I'm not signing this. Didn't do that either. He's back on track, back resolving all the issues. So I don't think the trial court acted arbitrary, capricious, unreasonably. There was no prejudice to him with respect to this. But it does raise an interesting issue, because what happens? What happens if the court affirms the decision? We go back down, we have the hearing, and we prove all of the elements that were there that she had been meeting, and we waste all the court's time trying to get a consent agreement in the first place. And that would send a bad sign of telling people that you can change your mind after the consent agreement because by just saying that you needed a lawyer, and then you go right back at it and then prove everything that you had to prove anyway a year later. Because this occurred when he attacked her on, from the record, October 13th of 2018. And the pictures are there, part of the record and all that, and the affidavit that was set forth with respect to that. So the question still remains for the court to decide is, was it arbitrary and capricious? Did he have some sort of duress where it left him without free will to move forward with respect to this, even after negotiating halfway through and then continuing on with the remainder of the negotiation. I think from the record it's rather clear, and I think from the record the court did what it often does in these kinds of cases and allows the parties to negotiate, and they did. For whatever reason to this day, other than the fact that this is divorce and the parties are very litigious, they seem to just seems to go on and on and on for real no reason, because at the end of the day, if you look at how quickly he said, "Yep, give her the car," we know just how quickly this issue came and went, and ultimately was resolved by consent of the parties voluntarily.
And with that, your time is up.
Thank you.
Thank you. Counsel, you have your full 5 minutes for.
Thank you. One, the transcript is very short. It's 45 pages. Many facts that were discussed by counsel just simply is not in the record. I don't know where he came up with the facts. It's somewhat distressing to hear facts that aren't in this record, but I am confident you will review the record and determine what is in the record and what is not in the record.
We will.
I am also concerned with the way that we dispense with issues of right to counsel and issues of due process. My learned adversary spoke of that they spent 30 minutes repeatedly. I lost count after 3 or 4 times he mentioned that they're into this and they spent 30 minutes on a matter that affects people at a fundamental level. Clearly, the court should not be concerned with the fact that it was 30 minutes, an hour, 3 hours, or a day. The purpose is to serve justice and make sure people's rights are protected. The right of counsel is fundamental, and when there is a request for counsel in these proceedings, the court should have granted the right of my client for counsel. The issue when he talks in terms at the start of the case on page 3, my client indicated it was just served at 2:00 p.m. the day before. The court goes on and says we have 2 options: proceed with the hearing, or you can make a determination, or you can have a consent entry. That's the only thing that the court says. If you go then jump to page 25, which is not very far in to this, my client indicates, "I am so sorry. I think I'm going to need to seek counsel. I am so sorry to waste your time here today. Is that okay?" The court responds, "Well, I mean, the options are either we can proceed with the hearing or we have a consensus to this." My client goes on to say, "Even though I was just served yesterday, my attorney wasn't able to show today, less than 24 hours notice. All I'm asking is for a little bit of time to hire a lawyer." Then the court goes on. I guess the issue is that we have been doing this, and if you were unsure going about what happened, you didn't request a continuance before. Client goes on to state, "I just got served. I just found out about this yesterday." How is that not a request for a continuance properly being made by a pro se litigant? He's saying, "I need time and I want to hire a lawyer." The court went on to get a consent entry, I believe, improperly, and it is undue influence and undue pressure upon the litigant who appears there. And it also, the court should have inquired about the right to counsel. And I want to stress this. Other courts throughout the state do require people that proceed as a pro se to sign a waiver of counsel. And the waiver form is very specific. It sets forth that they've been notified that they had the right to counsel, that they voluntarily waived the right to counsel, and they're proceeding despite being advised of their rights. And then the reason why courts are doing this is because of the explosion of pro se litigants. They're in all counties, all courts, and how hard is that to make sure people are aware they have a right to counsel, especially for something this severe? And again, when you read on page 36, when my client says, when counsel says, "I'm only asking for a 3-year order," so he's requesting that from the court, that the court should go along with that, my client says, "No, I want a 5-year order." Who does that if they're clearly thinking of what they're doing and if they know the ramification? Clearly that should have notified the court that something's wrong. When you read it, it is just shocking because you will say to yourself, why would a person ask for a 5-year order? He believes it's going to be on both of them, despite what is being said and done. And a court sitting in these small rooms can get people pretty much to sign most documentation on these orders after this goes on, where a denial of a request for a continuance and a denial of the right to counsel. I'm sure this court is well versed in the right of counsel, of people having the right to have counsel present during legal proceedings. The court disregarded my client's right to counsel, to secure counsel. Most people cannot get an attorney in that short period of time to show up at a hearing. And so most people go in, request a continuance, say I need to hire counsel, and it's continued. The ex parte order is already in place. Where is the harm? Where is the harm to anyone? Counsel talks about inconvenience, that somehow the court will be inconvenienced or people will be inconvenienced. Shouldn't we do it the right way the first time? Grant a continuance, let counsel comes in, because if counsel's present, even if you assume he did everything that's claimed, counsel will protect the person's right. Clearly, counsel's not going to agree to a 5-year order when the request is only 3 years, but nevertheless, I humbly request that the court reverse the trial court's decision. Thank you.
All right,
Appreciate
thank
your
you.
time.
Thank you both for your arguments. We will take the matter under advisement, issue our written decision in due course. It will be mailed to both sides, as well as posted on our website, and that is Supreme Court. You both have a good day.